Counsel, you said right at the outset that there's a federal interest that the people on each side of the case speak with a single voice. Right? Where did that come from? I mean, just about every case we hear, we have two parties representing one side of the case, often with slightly different interests. In significant litigation in the federal courts, you have the same thing. If the sovereign state that is a party in the case has a law that says these people have to represent us, I don't know of any federal interest that outweighs that.
I think the federal interest is in having the state tell a federal court what its position really is. So petitioner's whole argument here is that, enforcing state law A, enforcing the voter ID law or defending the voter ID law might conflict with an interest in election administration. We don't think that's a different interest, but if you think it is, and if you think there are different state perspectives here, there's a really strong federal interest in not allowing the state to say, we want our agents to duke it out in federal court. So, put differently, the possibility that different state agents defending state law might have different perspectives and balance state interests differently it's a vice, not a virtue of their proposal, because it requires federal courts to referee instead of just telling the state, look, pick someone to tell us how the state law balance comes out. You can get rid of the attorney general if you want to in all cases or all election cases or, our case, but you should pick. And that's not a problem in other cases where this court has had, two state representatives like Brnovich where, they disagree about a question ultimately of whether the state statute violates federal law. That's a question that's in the federal court's wheelhouse. But here, how to balance a state interest if it conflicts is something that the state should really just be coming into federal court and telling the federal court what the position is.
That's a pretty a pretty difficult eyebrow-raising thing for a federal court to do when you have a political controversy with two different entities, each one having a right to intervene under state law as far as the state's concerned. And you're saying the federal court, before you even get into this dispute, which obviously under those scenarios is intensely political, you pick, I don't want to say you pick the winner, but you pick who is the real representative of the state. I don't see federal courts doing that as a general matter, or if we do ask them to do that, that's putting them in an intensely political position, when they are used to, in lots and lots of cases, having people, more than one interest represented on one side of the V.
Well, we're not telling the federal court to pick. We're saying when there's, a duly authorized representative who's already there, who's already actively defending the state, we'll stick with that person unless there's a really good reason to think that they're not doing the job. And again, the state can always kick them out. But this is consistent with federal statutory law on intervention. So Section 2403B says, we'll allow intervention of the state if there's not already someone in there defending state law.
Well, but the federal side is very different. We have a unitary executive. The one person should speak for the United States. States don't have to have that same perspective.
Well, Section 2403B is specifically about intervention by states. And what it says is a state can intervene as of right if there's not already a state agency or state officer who's a defendant. So I think federal law really strongly supports our view that there should be a presumption of adequacy when you already have one state officer in there as a defendant defending state law. So I don't think we're asking the federal court to pick. We're saying you stick with the one who's there. And by the way, the defendant who's there is going to be the one who's, the only permissible defendant under federal law.
So if the legislature had entered an appearance first, they would be the one there?
Well, the legislature wasn't a defendant. I mean, we sued the only defendants that we could sue under Ex parte Young, which would not, of course, include the legislatures. So I don't think, as I say, I don't think the federal court is picking. And again, the state of North Carolina can kick the attorney general out at any time it wants if it really thinks he's not adequate to defend the state's interest in the voter ID law. And it hasn't done that here. And as you say, I think there's a really strong federal interest in just telling the state, you choose who represents you, but we want to know what your position is in federal court.
But isn't their position that